Good morning, everyone, and welcome to those who are joining on the recording as well. This is the 39 Essex Chambers breakfast seminar looking at the newly published Bill of Rights and very much focusing on the practical implications for practitioners, what we've described as a practitioner's guide. I'm Steve Broach, I'm a barrister in Chambers, and in keeping with our practical emphasis this morning, joined by a panel of excellent juniors who are going to be taking you through some of the key implications of the bill for rights protection in the UK. Now, on one level, of course, the practitioner's implication of a Bill of Rights are zero because it's only a bill. But rather than us all go home at this stage or go off on with our day, we're going to be looking, of course, at what may be the changes that the new bill would introduce if enacted in anything like its current form. And there's been a huge deluge of commentary about the bill, the vast majority of which has been negative. Looking at some of the incredibly helpful commentary by Professor Mark Elliott and his initial Twitter thread, his rapid reaction blogs, my headline take is that if this bill went through in its current form, we would still have the form of rights protection, but we would lose very much of the substance. And it would become much harder in practical terms for our clients to enforce their rights before the domestic courts. So that's the thesis that I'm putting forward. And I very much look forward to hearing what my colleagues have to say about some of the key issues that we've identified within the bill. So I'm joined today by Emily Wilsdon, Katherine Barnes, Steph David, and Nyasha Weinberg. And the issues that they're each going to be covering. Steph's going to be talking about the removal of the interpretative obligation, so the current Section 3 Human Rights Act obligation, and the potential for increased roles for declarations of incompatibility. Katherine's going to be talking about the restrictions on that the bill seeks to place on judges' interpretations of the ECHR rights, so looking at clauses 4 to 8 of the bill. Emily will focus on overseas operations, the new permission test that's proposed, and the restrictions that the bill would place on the award of damages and other remedies. And finally, Nyasha will look at the relationship that the bill seeks to extend over the European Court of Human Rights and other international law issues. We are going to rigorously stick to our timetable, leaving us, we're going to try and finish, well, we will be finishing on the dot of 9:30. And that will leave around 10 minutes for questions. And please do use what I'm sure is now familiar to everyone, which is the Q&A function at the bottom of your screen. We're in webinar mode, so that's the only way in which you'll be able to communicate with us, and I'll be monitoring that as colleagues are speaking, and we'll put questions to the panel at the end and perhaps deal with some as we go along as well. I think that's all we need to say by way of housekeeping. Sorry that we can't provide any of Chambers' excellent refreshments for you all. I hope you are all suitably refreshed and adequately breakfasted at home. And I believe that the first speaker is going to be Steph, looking at removal of the interpretative obligation and declaration of incompatibility. So over to you, please, Steph.
Thanks very much, Steve. So as Steve indicated, I'm going to be focusing on the interpretive obligation and increase role of declarations of incompatibility. Essentially, there are 5 main points to my talk. The first one is just reminding the audience how powerful the Section 3 interpretive obligation is. Second is looking at the removal of that tool within the Bill of Rights. The third is in respect of implications for case law reliant on Section 3. The fourth is with regards to the increase in declarations of compatibility and claims to Strasbourg. And the fifth is the tools that the courts will be left with. So early morning, we got a very fresh-faced Tony Blair for you, actually from 1994 rather than 1997. But you'll probably recall the principal purpose of the Human Rights Act was essentially to allow those within the jurisdiction to enforce their rights under the European Convention in British courts. And that's rather than having to incur the cost and delay of taking a case to Strasbourg. And indeed, as the House of Lords recognises it then was in Gardet and Godin Mendoza, the broad sweep of Section 3.1 is indeed crucial, or was crucial, to the working of the 1998 Act. So in terms of looking at the provisions of Section 3 of the Human Rights Act, just to remind you of exactly what it says, it's mandatory, it's an obligation, and it applies both to courts and to public authorities, which I think is often forgotten. And actually, there are two obligations within that provision. The first one is must be read, which is an interpretive obligation. And the second is given effect. And of course, that ties in with the current Section 6 of the Human Rights Act. And what's unique about this interpretive obligation is that it applies even if the statutory language admits of no doubt, and it still permits legislation to be given a different meaning. So most obviously you hear references in the case law to reading down a provision. Very recently in the Supreme Court, it was acknowledged that the interpretive obligation is remarkably powerful and it goes beyond the normal canons of statutory interpretation. The ultimate purpose is to interpret the legislation in accordance with the fundamental rights recognised in the European Convention. And of course, the limit to that interpretive obligation is in respect of the grain of the legislation. So it's not open to the courts to go beyond the grain of the legislation. I provided there a recent example of a case that I've been involved in with Jenny Richards and Katherine Dobson in Chambers. It's a case which was brought against the Human Fertilisation and Embryology Authority. And again, it just shows the power of Section 3. In that case, Mr. Jennings was seeking a declaration that it was lawful to use his jointly created embryo with a surrogate. His wife had unfortunately passed away in the fourth cycle of IVF. The argument that the HFEA ran was that there was no written consent from her to the effect that he could use the embryo with a surrogate. And what the court did is they identified that the principal feature of the legislation and the regulatory regime was consent, and written consent was an evidential rule to prove consent. The court therefore read down the requirement of written consent in accordance with the Section 3 obligation and found that in the circumstances, his consent could be inferred, or her consent could be inferred. So it just shows the power of that obligation, notwithstanding the express terms of the legislative regime. So moving then on to the removal of the tool, the key clause is clause 1.2 of the Bill of Rights. And as you see there, the courts are no longer required to read and give effect to legislation, so far as possible in a way which is compatible with the Convention rights. And further, clause 10 provides for declarations of incompatibility. And you'll see there the various subclauses in respect of when that applies. I draw attention in particular to 10.1a, which is the court is satisfied that provision of subordinate legislation is incompatible with the Convention right, and the court does not quash the provision or declare it invalid by reason of the incompatibility. And again, 10.2, ultimately this is the power, it's not an obligation, and therefore it differs quite significantly to the previous legislation, or the current legislation, I should say. That clause applies not to the lower courts, not the county court, but from the High Court upwards and the Court of Protection. So the next question is, what happens to the case law relied upon Section 3? So when you're looking at repeal of Section 3, it is important to note that it's accompanied by a power on the Secretary of State to make secondary legislation to preserve the effects of interpretations made under that section. And you see that's from the explanatory notes. That is obviously rather unusual because strictly speaking, Section 16 of the Interpretation Act would mean that repeal does not affect the operation of the repealed legislation. Just to flag on that particular point, however, that the impact statement from the government has indicated that they've identified approximately 60 cases subject to Section 3 interpretations. And to date, they're only intending to amend or retain the interpretations of around 40 of them. And it just goes to show, doesn't it, that it really will fall upon what Parliament and the executive decides to retain. So the Bill of Rights ultimately envisages a shift in power from the judiciary to the parliament. That's a question there whether it's actually moving on to the executive. The impact assessment acknowledges that there will no longer be the immediate remedy provided by Section 3, and that claimants will have to instead wait for the issue to be resolved by Parliament. That, of course, brings into question Article 13 of the European Convention, namely providing an effective remedy in the contracting parties to the Convention. I just included there a quotation from the case of Kudler in Poland, which is a Grand Chamber case. Ultimately, the purpose of Article 13 is to ensure that human rights protection first and foremost happens within the state's own legal system, establishes an additional guarantee for an individual in order to ensure that he or she effectively enjoys those rights. This brings me to a quotation from Mark Elliott, the professor of public law and the chair of the Faculty of Law at the University of Cambridge, that Steve mentioned earlier. And it really ties into that broader theme that will be apparent from the Bill of Rights. He refers to what Boris Johnson's cakeist philosophy, namely the merits of having both one's cake and eating it. Of course, on the one hand, the UK is saying it's fully committed to the European Convention on Human Rights, and the Supreme Court is also lauded as the ultimate judicial authority when it comes to rights questions. But of course, the ultimate question for Parliament and for the UK Constitution will be what happens if and when there is an increase in applications to Strasbourg as a result of Parliament not acting on declarations of incompatibility. What then happens? And you'll see there, it's a piece of legislation the government claims enhances human rights protection, but which in fact significantly diminishes it. If, as is likely, this results in more applications to the Strasbourg Court, the government will then face a stark choice between accepting the court's judgment or defying them. So my final question before I hand back to Steve is in respect of where does the removal of Section 3 leave the courts? We have to look back to the traditional canons of interpretation. The first one to think about is the principle of interpretation that requires domestic legislation to be interpreted what should be compatibly rather than incompatibly with UK's treaty obligations. That is a statutory presumption that Parliament does not legislate contrary to international law. But of course, that will cause some difficulties in circumstances where there's content within the European Convention and it directly contradicts what the Bill of Rights says. The second point is in respect of the principle of legality, which requires law to be interpreted in accordance with the rights at common law. But the first question there, of course, is firstly, what is the content of the common law rights and what do they require? And second is in respect of when that principle applies, namely when there's ambiguity or generality in the statutory scheme, and therefore it differs quite significantly Section 3, which, as I said at the start, applies even when there's express wording to the contrary. But thank you very much, Steve.
Very impressive, Steph. You've left me with a minute to reflect. Thank you ever so much. So two points to reflect on that excellent presentation from Steph. First of all, we'll be left, it seems, with a much weaker interpretive obligation under various sources, and also with greater difficulty in obtaining declarations of incompatibility in practical terms. So the scorecard so far is certainly looking like significantly less like rights protection than we have presently. But also my immediate reaction listening to Steph speak is that this is going to be one of the many areas where the implication for practitioners is likely to be a lot more litigation. And for a government that tends to profess a certain degree of antipathy towards lawyers, it does seem rather keen on making work for us. And this will be certainly one area where there's likely to be a deluge of litigation, trying to understand what, if any, the new interpretive obligation is, or obligations are, on the sources of them, and when one can actually obtain a declaration of incompatibility if the bill goes through in current form. So that's the starting point. And now I believe we're hearing Katherine, as the slides is helpfully prompting me, looking at the interpretation of convention rights within the bill. So over to you, Katherine, for your 10 minutes, please.
Thanks, Steve. Morning, everyone. I'm going to look at 4 ways the bill restricts the interpretation of convention rights by domestic courts. So in particular, I'm going to be looking at undermining the convention as a living instrument. Also the fact that Strasbourg's interpretation of rights will be a ceiling, not a floor, the removal of positive obligations, and then my point 4, if I have time, I'm going to look at what appears to be an attempt to codify deference to Parliament at a very extreme level. So without further ado then, the first point, you can see from the extract from clause 3 that the bill requires courts in interpreting convention rights to have particular regard to the text of the convention rights, which I think is pretty uncontroversial. The courts would do that in any event. And in interpreting the text may have regard to the preparatory work of the convention. And the point here is that the preparatory work is supposed to evidence what the drafters of the convention intended it to mean, and therefore what it does in fact mean. And if there was any doubt about that, the explanatory notes make it very clear. They say reference to the preparatory work of the convention can serve to inform courts' understanding of the original intention behind the convention rights. And here we go, this is the crucial bit, and thus how the rights should be interpreted. So you can see that the bill is designed to push the courts towards an originalist interpretation of the convention, and therefore a departure from what's known as the living instrument doctrine. And in my view, this is extremely dangerous. And the difficulties of the originalist approach, if we needed reminding, have been well illustrated for us recently by various US Supreme Court decisions. And these, to my mind anyway, illustrate that the contents of rights have to develop over time to reflect society's changing needs and values. And otherwise, the convention just becomes a relic of the past that can, in fact, in some circumstances, be positively unhelpful. So that's the first point to flag, which I think is pretty concerning. Perhaps, however, far more concerning is my second point. And here, this is the issue about Strasbourg's interpretation of rights being a ceiling, not a floor. Well, what do I mean by this? And I have to refer you to clause 3.3 of the bill. You can see that courts in determining questions relating to convention rights may not adopt an interpretation of those rights that expands the protection conferred by the right unless the court has no reasonable doubt that the Strasbourg court would adopt that interpretation. And then if there was any doubt, we know that the domestic court may adopt an interpretation of the rights that diverges from Strasbourg jurisprudence. So what does that mean? Well, it means that the domestic courts can't go further than Strasbourg. They can't expand a right beyond what Strasbourg have said it means. But what they can do is reduce the right below Strasbourg's interpretation. And so hence the Strasbourg interpretation is a cap, it's a ceiling, but certainly not a floor. Now, at first blush, this may not be too concerning because the reality of our case law at the moment is that it reflects this idea of Strasbourg as a ceiling. The domestic courts have said now in multiple cases that they won't go further than Strasbourg in interpreting convention rights. And I put an extract from the AB case to illustrate that. But, and to my mind, this is crucial, the rationale for the domestic courts taking that approach and not going further than Strasbourg is based on the fact they recognise Strasbourg is the ultimate authority on the interpretation of convention rights. And so importantly, they go no further than Strasbourg, but they also go no less. So the logic of going no further than Strasbourg entirely falls apart, where we're told, first of all, that now it's the UK courts that are the authority on on convention rights, but also where the bill positively requires our domestic courts to undercut the interpretation of convention rights in particular scenarios. And I'll be coming on to a particular way that happens in a moment. So that the mirror principle, as it's been known up until now, entirely breaks down. The rationale for it does, at least. You can go no further, but then you don't have the protection of doing any less. So moving on to my third point, and this is about the removal of positive obligations. If you were confused up until this point, I warn you, it's about to get a lot worse. Just so that we're very clear at the outset, by positive obligations, here I'm talking about when a convention right requires the state to actively do something rather than merely refrain from doing something. And in respect of those sorts of rights, positive obligations, the bill dictates a different approach depending on whether the positive obligation already exists as part of our existing established case law on convention rights. Those are known as pre-commencement obligations, or whether we're talking about a new positive obligation or a potential new positive obligation, and they're referred to as post-commencement positive obligations. So the position is, in a nutshell, like this. For post-commencement positive obligations, so new positive obligations, there is a total prohibition on any of these. And in terms of our existing positive obligations, well, it's extremely complicated and confusing. Effectively, when the court is considering whether to give effect to existing positive obligations, it has to take, well, at least this is my understanding, it has to take the existing interpretation of that right. So it recognizes that the right has been interpreted to include the positive obligation, but the court then has to go on to decide whether to apply the positive obligation in a particular set of circumstances. And in doing that, it has to give, quote unquote, great weight to various factors specified in the bill. And these are, in summary, the impact on the public authority's ability to perform its functions, the judgment of the public authority in deciding how to allocate its resources, the fact that according to the Act, there should be no there should be no requirement for police to protect individuals involved in criminal activities, the need to avoid a standard of investigation that is higher than what's reasonable, and the need to avoid affecting the operation of primary legislation. I mean, a slight side point on that final issue about avoiding affecting the operation of primary legislation. I really don't understand what that means and what it's supposed to be getting at. So a few thoughts on what that all means in practice then. More simple to begin with the post-commencement obligations, so new obligations. This is preventing the living instrument doctrine from applying. So the law can't be developed in this way. So we are effectively stuck with rights at a snapshot in time when the Bill of Rights comes into force. And for the reasons that I've already said, that in the long term is really quite concerning, because it means that our rights protection is not keeping up with our changing needs and values as a society. And then the other, well, there are many things to say, but something in particular I wanted to flag as a difficulty with this The bill defines positive obligations very broadly. It says positive obligations means an obligation to do any act. But as you will all know as practitioners, the Strasbourg case law often doesn't distinguish either at all or clearly in any principled way between positive and negative obligations. And sometimes the court actually says, we don't think this matters. You know, we've thought about it and we're not going to discuss whether it's positive or negative. And so that then is really quite problematic, because there will be all sorts of future development of the law by Strasbourg that then it becomes very unclear whether that should be applicable or inapplicable in the UK. And given this very, very broad definition of positive obligations, that risks huge swathes of future jurisprudence by Strasbourg just not being applicable in this jurisdiction. And then in terms of the pre-commencement obligations, so the existing obligations, well, very obvious point, but it's a major curtailment of important rights. I mean, for example, you'll all know that Article 2, the operational positive obligation is to take reasonable steps to protect a person's life if the public authority knows or ought to know that there's a real and immediate risk to life. Now, clearly, I don't think I really need to explain how fundamental that is, and indeed how apparently unreasonable it seems. To get rid of that obligation or to cut it back would have real practical impact on all sorts of people's lives and rights. Then, as I've said before, there's this issue about the incredibly broad way in which positive obligations been defined. And then from a practitioner's point of view, real uncertainty in legal terms as to what public authorities' obligations are. I dread having to advise on this area. I mean, you have to first of all establish what their obligations were previously, and then somehow apply these factors, second guess how the courts are going to apply them as to how they relate to a particular scenario. So as has already been said, I also predict a major increase in litigation to clarify how these various factors are going to apply in different settings. I will draw things to a close and just end by saying then, in terms of key points, we can see a real undermining of existing rights protection. The bill also represents a real constitutional power grab. This delicate balance by the Human Rights Act is being disrupted so that the courts have much less power over these rights, and it now seems to be lying with Parliament, but therefore in practice the executive. And it's hugely complex and incoherent, particularly in terms of positive obligations. So I predict huge quantities of legislation on the horizon in the short term, at least.
Thanks ever so much, Katherine. So two just brief reflections on that. First of all, the originalist issue is, I agree, a massive concern, particularly for those of us who have a particular focus on disability rights, which essentially didn't exist at the time the convention was brought into being. And so much of the recent Strasbourg case law on disability rights has been influenced by the UN Convention on the Rights of Persons with Disabilities, and which now our domestic courts will be told not to be focusing on. Very concerning collision course being put in place there, one might say deliberately, between the duration of travel in Strasbourg and what our domestic courts will be expected to do. And then again, as Katherine says, in terms of positive obligations, it's just going to be an enormous mess, isn't it? And result in a huge bun fight as to what is a positive obligation and whether it's pre or post amendment and so on. Lots and lots more litigation on the horizon. Again, if the government has a policy objective of generating work for lawyers, there's no doubt that the bill will assist in the achievement of that objective. So I'll now move on to Emily, please, to look at overseas operations, the new permission test, and restrictions on awards of damages and other remedies issues. Over to you, Emily.
Thank you very much, Steve. And I will share my screen. And so hopefully you can all see my presentation now. Thank you. So there's no less complexity, sadly, as we move to look now at the clauses on when and how a claim can be brought, the overseas operation of rights, the extra permission stage that this bill would introduce, and damages. Starting then with clause 12, here you have the duty, you can see it in subsection 1, unlawful for a public authority to act in a way which is incompatible with the convention right. This can be a claim that they propose to do so in the future, and it can include failures to act. It excludes, however, acts to give effect to or enforce primary legislation, including via secondary legislation. These provisions need a bit of careful reading to work through, if that primary legislation is incompatible with the convention. How would that exclusion work? First, you have to know what effect the primary legislation is actually intended to have, looking at Parliament's intention, before you can figure out whether the primary legislation is incompatible with the legislation, which means that the Public Act based on it is excluded from an unlawful act of a public authority. And as anyone who's dealt with a case where there's a dispute about the intention of Parliament will know, this is not likely to be simple. Swiftly on clause 13, how would a human rights claim be brought? Two conditions, fairly straightforwardly here. Firstly, your claim or counterclaim has to fit into clause 2.1, which we've just looked at, unlawful act of a public authority. Secondly, you must be a victim or a prospective victim. And here we adopt the European Court's definition of victim. And one big potential problem with this is clause 13 incompatible with other legislation and treaty. The Equality Act 2006, section 30 of which establishes the equality and human rights condition and says they will have capacity to institute legal proceedings, including judicial review, very important power for them, and that they need not be a victim or potential victim of the unlawful act. And what about the HRC's Northern Ireland counterpart? The Northern Ireland Human Rights Commission, established by the Belfast Agreement, aka the Good Friday Agreement, and the Northern Ireland Act 1998. It again has broadly the same powers and under the legislation doesn't need to be a victim. Well, Schedule 5 of the bill we're discussing today does set out amendments to legislation that would be made, but there are none listed to the Equality Act 2006, so no answer there for the EHRC. And there are no relevant amendments listed for the Northern Ireland Act. So how on earth would this work? Important point to note, there is a further clause buried at number 37 to allow ministers to make further regulations to amend primary legislation. Another issue, compatibility with the Belfast Agreement more broadly, direct access to the courts and remedies for breach of the convention is written into the Good Friday Agreement, but is, as we've seen, is limited by this bill. This is a slide for any fans of the Derry Girls. The Irish Department of Foreign Affairs has said this is a fundamental commitment under the Belfast Agreement. It has serious concerns about the bill, and others have described it as a direct attack on the Belfast Agreement. Meanwhile, the UK government insists they're compliant, but they haven't explained how, and it remains a difficult and perplexing question. Lord Sewell resigned from the House of Lords after being filmed by The Sun on Sunday, allegedly taking cocaine at his London flat in the company of prostitutes. What on earth has this got to do with the bill? He described a political convention now named after him, the Sewell Convention, that the UK Parliament will not normally legislate with regard to devolved matters without the consent of the relevant devolved legislature. Could this hold up the bill if the legislatures of Northern Ireland, Scotland and Wales withhold consent, as they did for the Withdrawal Agreement bill in Brexit? Well, the Supreme Court in Miller confirmed that the convention is not legally binding, so this will only be a political or constitutional issue, and it's one recently raised by the Joint Committee on Human Rights. Moving swiftly on, clause 14, overseas military operations. This is one that the government is quite keen to talk about. Note the structure here. It seeks to prevent claims. It doesn't actually restrict the duty that we saw at the beginning of my presentation, but perhaps this distinction would be more of academic interest than practical. Clause 13.7, which I don't show here, drives home the point that claims relating to other acts overseas remain possible. So ones not relating to overseas military operations that wouldn't fall within this clause. Now, there's a lot I could say about the drafting of this clause and the many, many uncertainties that it throws up, possible effects on claims by soldiers and civilians alike. It also features very odd use of overseas military operations. There's no reliance here on any international legal definition of war. And here we have the concept of an overseas military operation, one in the course of which Her Majesty's forces, not anyone else, come under attack or face the threat of attack or violent resistance. What's the meaning and scope of an operation? It could be very broad. The UK's 2014 to present day intervention against ISIL in 4 countries, 5, Iraq, Syria, Libya, Tunisia, and Lebanon, is one operation, Operation Shader. What level of threat of attack is required? I could go on. It's fraught with difficulties. However, this is the big question. Is it compatible with Article 1 of the European Convention? And note here, shall secure to everyone within their jurisdiction the rights and freedoms. The Joint Committee on Human Rights does not think so, and thinks that there's all sorts of problems with this clause. I won't read the quote in detail, but you can see their points about basic principles, the rule of law, access to justice, and the enforcement of human rights. Government, in its headline statement, appears quite confident. Dominic Raab's letter to the Justice Select Committee suggests that this will limit the bill's territorial jurisdiction. But will it? If we dig a little deeper into the impact assessment, it tells a different story. This shows, in short, how unlikely it is that clause 14, if enacted in its form, would ever in fact be commenced. It is a proposal only, or a signal, and it's described as such in the impact assessment, which says explicitly that there is no unilateral domestic solution to extraterritorial jurisdiction, which we can understand as there is no means of escape from extraterritorial jurisdiction through primary legislation. They're not even discussing this with other signatory states yet, and they are considering how to resolve it with other signatory states. And the impact assessment is clear that clause 14 will not commence unless and until so-called alternative remedies are legislated for. What those might be, we can only imagine. So is clause 14 just an exercise in signalling? It would require a very surprising diplomatic development in the Council of Europe. It's not the sort of change I suspect the signatory states are keen to make, and they wouldn't be in a hurry to do so, noting that 2 of them, Russia and Ukraine, are currently engaged in war. I predict it's unlikely that this or any future government will legislate for any adequate alternative remedy that would satisfy the European Court and the states. We've already heard Mark Elliott, the University of Cambridge's quote about cakeism. And he suggests the bill rests on a false premise that it's possible to legislate domestically to manipulate or magic away treaty obligations. And this is an example of Boris Johnson's cakeist philosophy. While in the case of clause 14, I suggest that the cake will not materialise. Clause 15, permission, one of the centrepieces of the bill. Is it really as significant as it seems? I'm looking here really just at England and Wales. Scotland and Northern Ireland have slightly different provisions. All claims require permission unless they're in the Investigatory Powers Tribunal or relate to a deportation order, quite a significant exception there. The court would have to apply first the victim test, second, whether there has been or would be significant disadvantage. Now that sounds on the face of it quite strict, and there's an extremely limited get-out clause of wholly exceptional public interest, not wholly exceptional individual interest, public interest, and you only get one level of appeal. However, the definition of significant disadvantage is the ECHR's test that was introduced by a protocol in 2010 to help cope with that court's caseload. Dominic Raab has referred to the permission stage as ensuring trivial cases do not undermine public confidence in human rights, but this may oversell the clause. Trivial, as you'll see here, is not the opposite of serious, it is closer to de minimis. Something that is more than a minimum level of severity, not technical or insignificant. And you look at it subjectively as well as objectively, and you look at the importance of the principle at stake to the individual as well as any loss. In reality, would the permission stage save the court's time, or would it be an extra administrative burden on already stretched courts? I'll leave that to you to consider. Finally, clause 18 on damages. Clause 18.1 sets out the requirements for an award of damages to be made. Actual loss and damage. However, note that that is the requirement for an award to be made. It doesn't limit the actual quantum of the award. And awarding damages must be something that the court has to do for the overall award to be just and appropriate. It doesn't apply to a breach of Article 5, the right to liberty and security, and there's no explanation of that in the impact assessment. Clause 18 is really, if you look at subclause 3, all about putting a ceiling on damages, no more than the European Court of Human Rights would award. In making decisions about loss, damage, and whether to make an award, the court must consider all the circumstances, including those in subclauses 5 and 6. It's not a closed list. Subclause 5, they're mostly pretty obvious things, but the headline here is that they include the claimant's conduct, even if that conduct is not related to the unlawful act. So this could be if you have a completely unrelated criminal record, or perhaps even just an accusation. And subclause 6, the court must give great weight to the importance of minimizing the impact that an award of damages would have on the ability of the public authority or any other public authority to perform its functions. And that includes the court considering future awards of damage which may be made in future cases involving issues that are similar to the unlawful act. There's a lot in there, and we could probably devote an entire hour to this. It's really unclear how it would be applied in practice and how defendants would be expected to evidence the impact on the performance of their functions. What, for example, if their ability to perform a function is already heavily impacted, maybe by lack of funding? And how on earth would courts assess the likelihood of future cases? What does the use of issues mean? And would this apply to cases that haven't crystallized yet, haven't been issued, or where there is not yet any act or even any intended act? I predict the courts will have to deal with a lot of broad brush assertions if this clause is enacted. The impact assessment, I've got a selection of quotes here, admits that clause 18 may put off some claimants, particularly those affected by the conduct point. For example, those bringing claims against the police who may have their own conduct brought up at the damages stage. Whether there would be cost savings or cost burdens from this clause is very unclear. My prediction is that it might simply mean that more efforts are directed into tort claims, up to the European Court of Human Rights itself, and into more complex satellite litigation. Thank you very much.
Thanks very much, Emily. Yet more messy stuff that's going to result in a significant amount of post-enactment litigation if the bill goes through. And just to mention, Emily spoke at the beginning about the commissions. Lady Hale spoke about the bill to the Northern Ireland Human Rights Commission yesterday. I haven't yet had a chance to review that, but that will obviously be a speech that is worth some consideration. Just to flag that the slides and the recording for today will be sent out to all those who've registered after the event. So finally, we move on now, please, to Nyasha.
Good morning, everyone. This morning, I'm going to be speaking about the Bill of Rights and the relationship with the UK Supreme Court, the bill itself, the European Court of Human Rights, and international law. So the Bill of Rights at Clause 1 sets out, slightly unusually, the bill's aims, which are to repeal and replace the Human Rights Act, which means that it is not just a revision of the Human Rights Act, it's a wholesale repeal and replace. This reflects the themes of the Independent Human Rights Act review, which considers a series of questions and explicitly the relationship between domestic courts and the European Court of Human Rights. The bill, in its introduction at Clause 1, states that it will clarify and rebalance the relationship between UK courts, the European Court of Human Rights, and Parliament. So who does that power go to? Well, in the introductory statement, which acts somewhat like explanatory notes, it says that it is the Supreme Court that will determine the meaning and effect of the Convention rights. In repeal of Section 3 of the Human Rights Act and at 1(2)(b), it states that the courts are no longer required to read and give effect to legislation in a way which is compatible with Convention rights. And at C, it states that the courts must give the greatest possible weight to the principle that in a parliamentary democracy, decisions about the balance between different policy aims, different convention rights, and convention rights of different persons are properly made by Parliament. It also emphasises then at 3 that the European Court of Human Rights role will be newly limited. Whether they can do that, of course, I will come on to discuss in the remainder of this talk. But it affirms that judgments, decisions, and interim measures of the European Court of Human Rights are not part of domestic law and do not affect the right of Parliament to legislate. Now, all of this is taking place without any actual change to the UK's international law obligations, because it remains the position that there is nothing in the Bill of Rights which changes the UK's position in international law. the UK remains subject to the binding treaty obligation as a signatory and state party to the European Convention. Plus, there is a common law presumption that Parliament does not intend to act in breach of international law. Further, and as was discussed by Emily, the Good Friday Agreement or Belfast Agreement requires the Convention be given direct effect in Northern Ireland courts. So, how does the bill actually and technically work to promote the Supreme Court in relation to the European Court? Well, through Clause 3, which asserts the Supreme Court as the ultimate judicial authority. It also reforms the HRA Section 2 obligations, leaving courts no longer required to take account of the European Court of Human Rights jurisdiction. It also requires UK courts, as was described by other speakers today, to have particular regard to the Convention right text, that it may have regard to the preparatory work of the Convention, and may have regard to common law rights and principles. Implicitly, this sanctions a level of diversion from the European Court approach. And as was discussed before, it moves away from the notion of the Convention as a living tree or living instrument. Clause 3.3a prevents courts from expanding the protection conferred. But note, in order to determine what an expansion might look like, effectively UK courts are going to have to domestically do an act of judicial second guessing about what Strasbourg courts would have considered an extension of the right. And this is one of the many issues that may create an ongoing and sustained tension between domestic and Strasbourg jurisprudence. Some further examples of way in which divergence takes place, and this is because the way that the Bill of Rights clauses are worded demonstrates government willingness to open up the gap between the case law of the European Court and the UK's treaty obligations and domestic application of the Convention. Examples, and some of those are issues that have already been discussed, is Clause 5 on positive obligations. So the construal of positive obligations on state institutions in a way that diverges from the European Court's jurisprudence on this issue. Clause 8, which results in UK courts concluding, may result, it depends on how judges interpret it, concluding that there is not a ECHR breach when in fact there is one, and Clause 4, which requires European Court interim measures to be disregarded. This is potentially following the Rwanda decision, and that may well lead to additional tension between the European Court and UK courts. In respect to declarations of incompatibility, this has already been covered today, but just to reiterate, Clause 10 maintains power to issue declarations of incompatibility where a court is satisfied that a provision of primary legislation is incompatible with a convention right. It's hard to know ultimately whether such declarations will be more or less likely under the Bill of Rights compared to the Human Rights Act. And that's given the provisions in 7 and 8, which reduce likelihood of a declaration being made. But the absence of an interpretive obligation may result in there being more incompatibilities. Whichever way this ultimately goes, it's important to note that a declaration of incompatibility is not an effective remedy under Article 35(1) of the European Convention, which means that in circumstances where such a declaration is made, it is possible for litigants to go directly to Strasbourg. And it is one area in which the UK is exposing itself to an increased weight of Strasbourg litigation. Ultimately, it's important to remember, and in the language of Brexit means Brexit or the KKIS philosophy, breaches of convention rights remain breaches of convention rights. Nothing contained in the bill can change the position in international law. UK divergence could result in a breach of the UK's treaty obligation under the ECHR. The questions as to whether the UK has complied or not with the convention remain for the court to determine, regardless of what is contained in the bill about the domestic interpretation. Internationally and under international law, it's still for the European Court to determine. Thus, the rebalancing that has taken place, the shift that is written up in the introductory clause from from the Court of Human Rights to the Supreme Court is solely from the perspective of domestic constitutional legitimacy. The UK therefore may find itself in Strasbourg more often. The UK will still be required to comply with Strasbourg decisions to which it is bound by treaty law. Thus, litigants, or at least those litigants who can afford it and have the stomach for it, can still go to Strasbourg. The new legislation, and particularly those clauses which enable a degree of diversion from the court jurisprudence, means that the UK will often be more likely to be found in breach of the convention. Thus, overall, the position is that it will make it more expensive and burdensome for those seeking to rely on convention rights in domestic courts, because it will require them to go to Strasbourg. And in particular, that will be particularly complicated in those areas which have been expressly restricted and discussed by my colleagues in the proposed Bill of Rights. So overall, it appears that the government's strategy is to reduce the influence of the European Court, but this is without removing the UK from the European Convention. What this leads to is a strain in the relationship between the UK Supreme Court, or at least a potential strain, and the European Court, and ultimately a strain between the UK's relationship with the Council of Europe. Lawyers and creative lawyers are likely to find wiggle room using the provisions within the bill to find routes to refer to Strasbourg jurisprudence in domestic courts when determining convention rights. And we will see how that plays out in the litigation that is to follow. Consequently, the new situation is somewhat confused, with the government attacking the Human Rights Act and limiting ready enforcement of rights while still remaining bound by the European Convention. This, as I've said before, is going to lead to confusion and litigation. Thank you, and back to you, Steve.
Excellent work, Nyasha. Thank you very much. Well done, team, for keeping to time. Just two reflections on Nyasha's presentation. First of all, making the point that the repeal of the Act, as the bill would, repeal of the Human Rights Act, as the bill would create, was not in the last Conservative manifesto. Pledge was to update the Human Rights Act, which I think is a very different thing to repealing it. And so we've had several questions about how to stop the bill becoming law, which is beyond the scope of this talk, but it perhaps is worth noting that on the basis that there was no manifesto commitment, the House of Lords might be willing to be rather more robust in its scrutiny / opposition to the bill as it progresses than it would have otherwise. The other important point that I'd like to pick out from Nyasha's talk is about the increased likelihood of applications to Strasbourg, including where declarations of incompatibility are made. And it does seem to me that that's obvious as a consequence of this approach, and therefore must be deliberate, and that there must be some kind of understanding and perhaps even happiness at the prospect of greater confrontation between the domestic authorities in Strasbourg. But again, that's perhaps beyond the strict scope of this morning's talk. So that does leave us with a few minutes for questions, and we've had some really good questions come in. Thank you very much. Let me just go back to them and pose a couple to the panel. So the first question is a very interesting one. Do we think, panel, that we're underestimating, or that perhaps government and parliament are underestimating the bench, insofar as there will still be a power to interpret in line with the convention? And is there a possibility the judiciary will go further than parliament would perhaps like? And perhaps within that question, we might explore the role of the common law in filling any gaps that may result from the bill. Would anyone like to come in on that? If not, I'm going to be mean and put it to Katherine.
Yeah, I'm happy to start on that. Well, I think there are two aspects to it. Unfortunately, if this goes ahead, it will be primary legislation. And so judges don't have discretion under our constitution to set that aside. So they are hemmed in. This is a judicial straitjacket, if you like, by what the Act says. Now, where the Act allows leeway, so it's a question of judgment for the judiciary, then I expect and I hope that they will push back and be robust. So, for example, when I talked about positive obligations and that list of factors the judges have to think about, maybe I'm being naive, but I hope and I somewhat suspect that actually judges will not, in many occasions anyway, disapply existing positive obligations because of those factors. Now, there's a separate question then of the common law and whether that can be used to plug the gap, because that is within the control of judges and they're not hemmed in by Parliament. But of course, the common law rights are different from convention rights. Sometimes they overlap, but the judges can't say, oh, we're going to use the common law to develop Article 2, for example. That would just be outside of what they can constitutionally do. So I think it's going to be a matter of looking at existing common law rights and seeing if they can be incrementally developed. Now, I have no doubt that there is some scope for doing that, and that's something that all of us as practitioners will have to turn our mind to. But I don't think we should underestimate the difficulty of doing that, because common law rights are not clearly defined in the same way. I always find it quite difficult to work out exactly what they are and how they're defined. And then, of course, persuading the judiciary to go further and develop a common law right is really, as well, Steve and I know from a case that we did quite recently, is really difficult with the vast majority of judges, and they're normally only prepared to develop them ever so slightly, if at all. So yes, some scope, but I don't think it goes anything like far enough to correcting this problem overall.
Thanks, Katherine. So we've got 3 minutes left and we've got 3 panelists who haven't had a question yet. So I'm going to give each of you a question, please, and ask you to answer them for a minute each maximum. Steph, I'd like to give you this next one. What do you anticipate the impact of the bill being, if it goes through as enacted, on the everyday practice of public authorities? What's your headline take on how government bodies are going to respond to this new human rights regime?
That's a very good question. Well, in terms of the unlawfulness of acts contrary to the convention, essentially that is very similar. Section 6 of the Human Rights Act, so that would be very similar to the Human Rights Act. In terms of everyday practice, I think it's difficult to say because obviously it will take a significant period of time to bed in. So in terms of damages claims and the HRA, it has taken a good sort of 10, 15 years for them to gain in popularity. And therefore, I think the immediate impacts for public authorities are likely to be quite low, but obviously in due course, we're likely to see the change.
Thanks, Steph. Emily, I'll ask you this one, please. A very interesting question. Who would be able to afford to litigate their rights with the current legal aid situation? If we're thinking about practical implications, is anyone able to enforce their human rights anyway in the current system?
Well, victims certainly can. And whether the government really intends to remove from the EHRC and its Northern Irish counterpart the ability to take direct enforcement action remains to be seen. So there's potential there too. However, from a very practical point of view, there is so much uncertainty in this bill that if it's enacted the way it is, it may be more difficult to get legal aid because the assessment of prospects for a claim will be affected by that very uncertainty. I mean, that will also affect defendants who are trying to figure out whether and how to defend claims and what evidence they might need. A lot of this is going to be answered, I imagine, in further regulations. There are broad powers for the government to regulate, this bill confer, and also in the rules of the court. So, for example, around the permission stage, where there is a lot of uncertainty potentially, is this going to be a brief, easy hurdle on the papers, or is it going to be something contested, maybe with an oral hearing that could become quite complex? We're going to have to look to the CPR or a practice direction or something similar to that.
Thanks, Emily. That was an extremely eloquent way of saying we haven't got a clue because everything's a mess. Nyasha, surely the UK Supreme Court cannot and will not allow itself to be limited in its interpretation functions by this piece of legislation if passed. I've put that question exactly as drafted. What would you say to that?
I mean, the UK Supreme Court will be bound by primary legislation to do what the primary legislation requires it to do. And if the UK Supreme Court is deemed to be overreaching, you can risk, seeing amendments in Parliament and further action by the government in the persecution or at least the pursuit of activist judges. And so I think the reality is that I think that there will be creative interpretation, or at least pushing the boundaries of what is possible in recognition of the tension between domestic law and between international law obligations that is likely to arise. But ultimately, whether this bill is brought into legislation, is turned into an act in its current condition, the Supreme Court judges will recognise that it has to abide effectively by the letter of the law, save for those areas in which there is so much confusion that they may well need to create common law to explain what the letter of the law is indeed saying.
Well said. So again, this comes back perhaps to conclude to the theme that from the outset, that although in form the bill seems to promote the authority of the Supreme Court, actually in substance, the content of the legislation, if enacted, would potentially erode it. And that, I think, is why sessions like this are so important, because the bill is not straightforward in its drafting, and it doesn't, I would suggest, deliver the headline message that's being put out about it. And I think it's been very clear by its reception and by the commentary that there are very significant concerns about the practical implications for rights protection if anything like the bill in its current form goes through. I'd like to thank very much all four of our speakers today. I think they've done a fantastic job of setting out some of the key implications for the bill. Thank you very much to everyone who's joined us. I hope we didn't put you off your croissant too badly by this slightly depressing analysis. We shall continue to watch this space. There will be more commentary, I'm sure, from us and others about the bill as it goes through Parliament, and no doubt at least will be amended. And we will continue to be paying very close attention to what it means for our clients, both as claimants and defendants in human rights claims. Thanks very much, everybody. And the slides and recording will be sent out to all those who've registered.